kia tātou. Kia ora tēnā ingo. Kia whakapapahana mi tui moana. Hei huara ki tātou i te rei nei. Aroha atu, aroha mai. Tātou ia tātou katoa. Ia tātou ia. Nau mai, mai ki te tāna o ngā kuri, ka uri, ka hura, ka horo. Kia.
Tēnā koutou katoa, ngā mai Awanui ki tēnā hui, ko Robert Scott Taparumo. Hello everyone and welcome to the hearing number 10, Māori Purpose So and Treaty Settlements on Overland for both Parliament District Plan hearings. My name is Robert Scott, I'm the Chairperson for these district plan hearings. With me on this hearing is Councillor Hilda Awanui and to my left is Commissioner Sam. I understand we have some students from the area of school coming in later on the scenes. Welcome. So this is the hearing of the Resource Management Act to consider submissions and further submissions of the plan. We are appointed by the Council and Independent Hearing Commissioners to hear submissions and make recommendations. As I say at the start of every hearing, we're not intending to issue any of the recommendations at this stage. We will be having interim deliberations as we proceed. My background is in planning, and I've been planning since 1992, and an independent commissioner since 2014 on the practice of Auckland, but also Queenstown, Christchurch City, Tauranga.
E kaikahi na Māori I heku. Me atu kia koutou, he taki Wendy nei te koe a tātou. Ko ngā kaupapa o ngā whenua Māori, I roki tēnei roki. So me atu kia tātou, I ngā kaifōrero te haramai ana te rānei. Te kura o manonui o wai te haramai ana, aini. So apologies for te rānei, my Nina Rahahui. Nina is one of these new commissioners that have been appointed and she wanted to come into the meeting today. But they're releasing turtles back to the ocean out of Putterfield. And I said, oh, lucky thing. So I know there's a whole bunch going out to that one. And the other one was from Trudy Allen, who's also completed a commission and also they talked about coming, just to watch the reading and see what it looks like, etc. Should they be called up. But namahi kia tātou, and big hui and Waitangi today, Waiora about the future of water. So we're all interconnected, whatever we're doing. Namahi.
Kia mai tātou, ko te tāne hoki tēnei, ki uri o Awanui, te uri, e okona te au tūpura, ko Hampū, ki te marae, and te Young Walker, te whenua. Yeah, I'm a planner, mathematician, and as part of this particular hearing process, in having a role alongside my holder to Māori voluntary outcomes, as well as my additional experience.
Thank you. I think everyone here is reasonably experienced with how we conduct hearings. So I won't go through those procedures.
Yes, sure. So bathrooms are out this door, to the right, left, and then left. Tea, coffee to your left as you come in, and water. In the event of a fire, please follow the green exit signs down the stairs, and the meeting point is in the car park. If everyone can just make sure they've got their cell phones switched off. To note, we are recording today's session and it will be going online to the public. Yeah.
Now, normally we have council officers introduce the provisions to us. Well, almost time. I mean, we've literally got all the days.
No, it's very brief. All right, I will just open up today's focus.
Oh, we've got everyone being in that needs to be here.
Now, yes.
Okay, so council officers introduce some topics to us.
I don't have the button, so you're just giving a nod and I'll jump to the next slide. Do you know how to cut to introduce a bit of I want to for the hearing today. So you can see on the land overlay. So just for
So sorry, Teresa, we did have a screen.
speak up.
Stand up. Whatever you want to stand, that's
Yeah.
fine. But if you just want to try and speak your voice a little bit,
Sure.
appreciate it.
Yeah, no worries.
Thank you, Chair.
Okay, the overview of submissions for these two topics today. So we received 37 original submissions and 106 submission points. Following that, through the submission period, we received 19 further submissions, which resulted in 159 submission points. The submitters for this topic, this chapter, the proposed district plan came mainly from area authorities in our district and some of their post settlement governance entities, Māori land corporations, hapu, whānau, and individuals, government agencies, infrastructure providers, and non-governmental organisations, and they covered a range of matters. For the treaty settlement land overlay topic, we received 28 original submissions and 94 submission points, 30 further submitters to those original submissions and 182 submission points. And as with the Māori purpose zone, the submitters came from area authorities, post-settlement government entities, hapu, government agencies, infrastructure providers, NGOs, non-governmental organisations, and community organisations. Thanks. Thank you. So for the Māori purpose zone, the key matters that were considered from submissions were submissions to the overview, objectives and policies for the zone, rules and standards, and submissions on general submissions on plan content, miscellaneous, and process and zone. The recommendations in the report were to retain the Māori purpose zone as notified, to make some amendments to objectives and to improve the clarity and intention of the zone, amend policies and to consistency, and more exceptions and titles to rules and standards. And there were minor corrections to address draft edits. Thanks, Andy. In respect to the treaty settlement land overlay, the key matters that were considered were similar issues, objectives and policies, rules and standards, general plan content and miscellaneous, some mapping, and to address a matter outside the actual overlay, the application subject to multiple provisions. The recommendations of the report were to retain the treaty settlement land overlay as notified, make some amendments to objectives, to improve clarity and intention, and policies, amendments to those for consistency, include broad exceptions and titles to rules and standards, mapping changes to correct errors and omissions, and the changes to notes and applications to subject to multiple provisions to assist plan users. And there was also some minor corrections to address draft edits. I think that's all the matters for the overview, just the box submissions. Thank you.
Nothing more to say about it. Quite similar.
Very much. Martin, Labour and
Well, I think we can now move to any questions. Any questions of council for this presentation?
This is colours you won't put our colour class.
We've got Lee and Tony. Oh, I didn't understand that one.
Sure. Thank you, Teresa, for that summary in regards to your Woodsway reports for both Queensland overlay and both episode. And yeah, all the collating and bringing that together and summarising everything. So I appreciate that. Thank you very much. I had a question, and if you have your version in front of you, I had a question related to the proposed plan variation. That's on page 12 of your 42A.
speaking with respect to the May request.
Sorry, I'm right, the right
Page 12.
yes, page 12. And in particular, it was around variation. Right. What I wanted to check in with you, in particular around paragraph 49 and 48 and 49, and it talks around the floor change variation, and there was minor amendments in relation to that. It's all about the airport protection services. And I just wanted to check in with you to ask the question, do you know, if any, how many minor land properties are potentially affected by that plan change variation?
I won't quite say no, but my recollection would be keen to be sure that maybe one or two. But I can check that and come back to you on that to be more accurate.
If that's okay, please, just to understand that context of what I've been indicated. Usually airports are in the villages anyway.
Yes.
So it's not subject to
My recollection of Kiri is quite the amazing one, and does apply to Kaiko Air, who also maybe one or two. But they're just off the top of my head, but I need to actually check the maps to be more accurate. But I can do that.
that. Thank you, just to be aware of potentially. Another point to raise, thank you. In the question, actually, so on page 5 of the Woodsway form design, in particular, there's reference to scope purpose of the report, in paragraph 14. 14, right. 14, C, D, C and D. Yep. There is reference in regards to the Wiri Whenua, seek to introduce a new zone, and the Bali properties seek a rezoning. Yes, the local design. And it just makes reference to hearing 15 rezoning. I just wanted to check which hearing potentially is about the rezoning. So it's A, B, C, and D. Well, we're hearing A is multi-purpose, open space, open groups, and character. Yeah, So it'll be A. It will be A. That's okay. Just a little bit of to, and I don't want to assume that, so that's the reason my question. Now, also, I have another question in relation to policy, in particular, policy 2, like people saying policy 2 on paragraph 88. Okay. So in the analysis.
Here with me, I'm just thinking.
That's okay.
In paragraph 88.
88. Yep. Test submission.
Yep.
It's one each. So in the analysis, it makes reference that the removal of the small scale may have adverse outcomes. Therefore, I recommend retaining the words small scale and inserting the words and other to enable outcomes stored. However, in your appendix A, what is policy 2, the small scale has been struck out, and which is fine, but the and other is within inserted. So it's sort of just sort of contradicted what you said.
That's an error on my part. Down here should be small scale retained and resource.
Well, that's what your report says. However, your instructions are different.
Yeah, so that's a contradiction. That's an error on my.
So are you wanting to retain small scale or delete small scale?
Just let me refresh myself on the report. Paragraph. And I haven't got just the appendix now.
That's okay.
Yes, so appendix 1 should retain the words small scale, not strike it out, and insert the words and.
Okay, because then that follows through with your treaty settlements. You're actually striking out small scale.
I've done the same.
And you're not retaining it. So the contradictory here is small scale has been removed.
Yeah.
From treaty settlements overlay. And that's what it says, the consistency, you remove it.
Yeah.
Sorry, I can't put the treaty settlement text here. But it was just this paragraph that was saying one thing and your policy says another.
No, I
Because the policy and the treaty settlement overlay has also deleted scale, which is what it says. So it's just clarification around it.
what from a procedural perspective, I can recall now, so in my initial draft, my 42, it was to accept the submission in full, and then following review, I made a change to that, and then failed to, that's what I was saying, failed to make a change in the intercepts. That's where the error was made. And then for consistency,
Yeah.
there wasn't recollections, there wasn't the same the submission. Well, no,
There
Right.
is policy 2 for treaty settlement.
Yeah.
This which
okay. So from a procedural,
it's just
what needs to happen?
so it's clarification of what the report says, because that's what people go back to.
Yeah.
And the action. Yeah.
Thank you.
And so we can clarify that. So that's just a particular question. Something I found, and this is not a written report, but the website is quite, the e-plan website to search for legal restrictions. I couldn't figure that out. So I found that some references that were made to legal descriptions. Because the pediatric groups on address these meetings. Okay, so that's okay, because there were references in the providing purpose standards that talked about RNDC and the transmitters and stuff. They have the legal description, but they didn't necessarily have the address. Once it's Spain, growing up, okay, I better get it. Sorry, that's just a.
Yeah. We know.
That's tree settlement. That's not purpose. I have got a couple of questions for the tree settlement overlay. Yeah. Apologies, I just so, the first question I think my purpose line and treaty settlement overlay. I have got a question that I'll talk to shortly after I've got the questions out of the way. So with policy one, this is page 23 of 42A, so because it does relate to something that really is on. Thank you. That'll be it. I'll leave it for now. Thank you.
I'll just say that I've got a few questions like that as well. What people want afterwards, what I hear the evidence first.
Yeah.
You probably just deliver these things anyway, and then once we've heard the evidence, we usually come back to you and we ask questions about draft and.
Thank you.
Okay. So yes, so I have some questions, but I'll bring them up later. Now we have Tapua Tahi. I don't know if that's correct. Is that a correct pronunciation? Tapua Tahi Incorporation. Mr. Sanson, good morning. You going to lead on?
Yes, sir. Give me a minute to just present to everyone.
And then you should be able to share.
Mai ki te kōrero o tēnei kaupapa, ki te kaupapa whakahirehira mō TV Māori, te taitoke rau huri ki a kawhiri, tēnei te mea te ki a te Teresa, ki te whakapuare te tātai nei hui, hoki ki a koutou mō whaipakawā te rā, tēnei te mea te ki a koutou. Ko Waio, ko Steve Sanson, ki o Hunua, he ori no te rarawa, me ngā tirang, ngā tīmore. Ngā ko.
Tēnā tātou katoa, te tupu te kōrero tō kama kei te taha, kia koe te sheita o tō karawhaki ki te rangi, ko tēnā ngā ngā mihi atu ki ngā kai o whakata wā. Ko toke rei te maunga ko Hirohara Mahai me te tiuranga marae ko Tapua Tahi ko Pareihanu te ahu whenua, te kaupapa ahu whenua, te whainga ki. So, tēnā tātou ko katoa anō. My name is Maria Opopai. I'm the Executive Manager of Tapatai Operation. Our entity that is the sole purpose was to look after our land and since has developed benefits to sustain it of our community. Just speaking to this, what brings us to the hearings here is around our subdivision and the potential rezoning of that subdivision, which was largely delayed for a number of aspects, starting with changing banking policies with BNZ, our banks. It took us a couple of years to work through with them, and then we got hit by COVID. So we probably would have been well down the track now with this COVID ahead, we not had those disruptions as everybody. But I just wanted to.
So yes, nothing else here to answer any questions about the incorporation itself. If you have any, there was an appendix to my evidence which sets out, I think, quite clearly and quite holistically what the incorporation is about, land holding itself, a number of shareholders and what they currently do. And just to summarise that, they've got a leasing operation which provides 51 sites from memory down the waterfront at Takotahi, with a balance of land serving a beefing unit. So a mixture of residential use and rural productive use. So, before I get into this presentation, so it's useful to reflect back on the operating context for Māori land. So 17% of the total land mass in the district is Māori land, and we've got 40% population. For the purposes of my evidence, provide further context, 10% of that 17% are land holdings that are more than 50 hectares in size. Okay, the rest are very small and discrete, less than 40 hectares. And I'll come back to why that's important, because I guess I'm providing evidence here around substantially larger land holding. And I think we all know the constraints or some of the opportunities that.
Sorry, that last number you got, so I looked in the down areas. You were saying, is it 1% of the sites are more awesome, the number of sites?
10% of the overall land holdings, Māori land holdings, are over 40 hectares. Yeah. So conversely, 90% or less. And if we take the rural production zone as a basis, that would be one site. You know, this conceptually, that would be one site under this plan. And so the constraints or opportunities the opportunities are little, but I'll phrase it in a positive way this morning, is that we have a growing Māori population. There's obviously the aspects around multiple ownership and fragmentation and disenfranchisement around that. We've got our 3 C's, which are our capacity, capability, and capital to make development happen, and even the smallest developments, so resources. A lack of servicing. I couldn't find it in a lot of our collective resources that we've got, but how much Māori land is actually urban. And so there is a complete lack of servicing, because I would say most of the land is rural. And the last constraint is disproportionately affected by overlays. So by overlays on the world famous SNAs, significant natural areas, coastal environments, high natural character areas, or outstanding natural character areas, which in my view have really come about from the preceding constraints. So we only now have high areas of vegetation, flora and fauna because of these additional constraints placed upon Māori landowners. So I thought it just useful to touch back on the operating context for a lot of Māori landowners. And I guess as another overlay to that is, which is the operating context for Tapuatahi, which is a large coastal landholding, which has a rating burden, which provides incentives, I guess, to change use in order to pay that rating burden, in order to make a buck. So let's on that wider level, let's start to slowly zoom in, I guess, into the localized context. So Tapuatahi beach here is directly opposite to T, near the Porirua Peninsula, 25 minutes of on driving, maybe half an hour, following the roadworks. So very close to this urban environment. It's really one of the only, it's not publicly accessible, but access to a pristine beach as well, and near proximity to Kirikiri. Here's a view of the beachside dwellings, and as you can see, they're quite tightly linked. They're served by a main road which comes directly from Taranui Road. Not as Taranui Road, sorry, from Porirua Road. And these sites are all currently self-serviced. Here's a picture from up above. So think of the site as having two tiers. The lower tier, which is directly on the coast and has a beautiful outlook. Then we come back a tier, and which is where you've got your rural farm and areas servicing beef. This is it as the site itself. So it extends on both sides of Porirua Road, and it does include the houses and dwellings there. Planning 101, it's not for everyone, just to provide the context. So from standing natural landscape features here, so very, let's say minimally involved with the planning environment and the development district plan. We have this cascade of zoning from the FNDC, which starts as coastal residential, very tight parcel layout. We've got this buffer area of coastal living. So much like the intention of the ODP was, in most cases, to provide a buffer from quite tight parcels or subdivision units before going straight into a general coastal or rural production use. And that's just the obvious, I think we're here to do for planning, is to manage the sensitivity, provide that separation and buffer. So here we have the PDP, what we're now is now being proposed, and so we're starting to bring a lot more of the newer features to light. Sites completely contain this Māori purpose rural. We've got high natural character areas, so that's the value of the bush that the regional council and now the district council are saying is so pristine it requires additional protections. And we've got hazards near the waterfront coastal edge as well as throughout parts of the site. So the stacking of these, and if you think about the current land uses, houses and beef farming, with the added overlays, it's sending signals to a landowner that maybe beef farming, which is already a marginal activity, maybe we have to think about other activities. And so to follow on from the leasing model, as well as provide opportunities for general housing, Tapuatahi have been working on how they could, so this area here is the area currently in yellow. Okay, so it's following the theme of, okay, housing, and current plan says, okay, let's keep the rest as a retire or use it as more of a production aspect. So in keeping with that, the corporation has gone through a process of identifying appropriate sites. This is done by Laterales Landscape Architecture, and determining the carrying capacity of their site through high-level engineering, through in the future down to detailed design to make this work. And so the submission originally presented was to say that this type of activity should be exempt from any planning rules, because when the plan was first proposed, it provided similar exemptions to the landholding and the towing. And so as a comparison, the towing also had an arrangement where it had coastal residential land, it had other zones there also captured up on this big proposed zoning. Instead of having multiple zones to reflect that carrying capacity, was now a blunt tool where we just had rural and urban. And so, to use an old saying, what's good for the goose is good for the gander. It's my submission that Tapuatahi promotes similar features to that exemption in Matodi Bay, and I itemise that a bit more fully in my evidence. Just moving to, I guess, the guts of the evidence. The overview, and I know we're not here to talk about the zoning, we'll come to the zoning at another hearing. But the overview sets out the purpose of the zone, and it's our position, my position, that it doesn't accurately reflect the scenario we have here. And that is where we have an urban fringe, an urban allotment abutting a rural block. I accept that there's a dichotomy there, but to zone it all as one, or to not call it multi-purpose urban because it's not serviced, I think that is the difficulty we will face when these are clearly self-serviced and they are urban. They're a character of urban. You know, if the definition is that every urban site needs to have reticulated free water, we can wipe out half the district, probably more. We already have commercial urban zoning that's not reticulated with those services, wipe up. So are they not urban? You know? So there needs to be some fairness, because if I may, the dichotomy that we're being provided, rural or urban, mostly rural because of my earlier context, where there's not a lot of urban multi-land, is that we're getting rural production right. That's all that multi-land zoning is being given.
So just to clarify that with you now. So you're saying that the small scale lots that are growing the beach should be defined by the scale rather than their infrastructure.
I guess the context is, sir, is that yes, that is one component. There might be others, but if they're self-serviced and not meeting a rural density or scale, then what are they? They're not rural. And under the ODP, we had these classifications around coastal residential and coastal living. We had a hierarchy of densities. And now with the multi-purpose zone, we're told realistically, your rural production light. And that's how I'm characterising it. You are multi-purpose zone, but everything's tethered to the rural production zone. And so, yeah, some of my comments are we've taken some of that nuance away. What's actually on the ground? Have we taken that into consideration, or have we taken a bird's eye view to just say that's multi-land? The underlying title says that's multi-land, so we zone that multi-purpose land.
Okay, so I'm just to clarify what the relief then. So relief still to keep the Maori purpose. This is to be Maori purpose in that section of page. Correct. Yeah. Okay. So you haven't the Maori purpose sign generally. It's just that you don't want it looks urban.
Well, I guess it doesn't matter what you call it, because the relief we actually seek is exemptions from residential activity in public homes. You can call it what you like, whatever it ends up at.
You run into the same issues with the urban zone. Because they're public homes too.
They do, but I think it's a reflection of the we go back to the carrying capacity argument. That frontal edge is developed. So now we're now talking about existing in future.
So it's your relief. I'm just trying to understand what your input is. So your input is we'd like that part of the land to be reclassified Maori purpose urban. And if you do, we still want changes to public area housing as well, or are you quite happy with Maori purpose?
Sorry, so our submission is for the rural area to make the changes to those rules.
Oh, yeah.
Yeah, so to clarify.
Your public area housing is to go into the rural, that's not.
Yeah, correct.
But you still want the beach bit to be reclassified as well.
Yes, correct.
In recognition of what's there.
Yeah.
And then you want the public area provisions changed to allow definite provide for further public area and rural.
Yeah.
But you're not seeking for that bit to be rezoned. It's just changing the Maori, well, not say rezoned. Quite happy for that bit to stay in the Maori purpose rural. It's just tweaking the provisions.
Well, yeah, it's a bit more than a tweak.
Yeah, I was going to say,
Yeah,
tweak is doing a bit of heavy lifting.
yeah.
Yeah, fine.
Yeah.
Just trying to clarify.
Yeah, sure. So I'll move to that second tranche, which is the exemptions. So obviously it's going to be a hard, that's a hard ask to be exempt from rules. And we've got this cascade, I want to call it, where there's an interface between what this definition around residential activity is versus what a public hire is, and that's confusing in itself. But that's why the relief is sought to be exempt from both initially, because if you look at the definitions of the residential activity, I don't see how there's any difference between that and the public hire. So that's just an aside. That's what prompted the argument to be exempt from both. And if that's too hard a pill to swallow, so my evidence is that at the least, residential activity development should be a restricted discretionary activity. So that's the compromise, so to speak, for you yourselves to take into consideration. Now, in terms of public hire, sir, the activity is obviously limited to 10 residential units per site, and that's great for that 90% I was talking about earlier. 90% of the Māori land, that's amazing for them. They might only have a hectare and then get 10 houses. But for a 300 plus hectare site, we're back to being rural production light, which is one house per 40 hectares or 10 residential units, whichever is the greater. So my last submission is around commercial activities, which we agree with. The definition of the Papakanga includes a large range of activities, and they don't need to specifically be small scale. Just before I go to some miscellaneous things, there is policies that are quite important within the multi-purpose zone, and that's around which I think gives credence to our argument that it's about the site servicing, I believe, of the site. In my experience, sir, the larger the site, the more it is capable of developing. So you've got this inverse relationship, so to speak, where for those 90% of land holdings, they see the ticket, 10 units, amazing, but the site capacity might only 4. Whereas you've got the larger section saying, well, actually our capacity could be 150. So why are we being put through this process? Some miscellaneous matters, sir, and it's not directly within my evidence, so you can take it with a grain of salt, but I just thought it'd be useful to point out there's a rule now that a site suitability report be provided for the council to be permitted. So for any activity, even if you meet all the standards, let's say you meet the standards for building coverage, is the rule saying you need a site suitability report for those? So it's just, I haven't gone through it with a lot of detail, but it's just something that jumped out at me, that a site suitability to be provided for non-rural activities seems like maybe one, resource consent department or whoever's looking at them might not be that an efficient process, or is it just when consents are coming through the door? That's a different proposition. To provide a third-party report to be permitted is different to being permitted. But happy to answer any questions in panel.
Kia ora. Meri moto kōrero. I te tingatanga ko tēnei kaupapa o tō corporation kia mauhere ki ngā whenua. Is that the purpose of your corporation? Hold your ladies together?
Yeah, look, sorry, I wasn't sure how much time I had to start, but otherwise I would have summarised my brief of evidence for that.
If you'd like to do that now, we'll allow that, because we've got plenty of time today, and I want to give you every opportunity to present it. So if you'd like to spend some leisure time, and I've got to present some, so I can speak to you, and also answer question.
Thank you very much.
Okay. So also, obviously, you've got a translation service here, so I'm not listening to Channel X. So we've got a translation service here, so feel free to speak to Ray if that's what you would rather do.
The Tuputai Incorporation was started in 1964 for amalgamating 3 parcels of land for the purposes of getting some kind of economic scale to pay the rates. There was so it's well documented that there was a very aggressive rating scheme back then. My grandmother's people in Matodi motorcade there just to pay the rates. And so to hold on to our land, we formed an incorporation to try and get economic scale for a farming operation. And back then, a farming operation rendered enough income to do so. And the vision for what our tupuna left us by Hilda is take hold of the people you need to eyes, and the land ever wants. And that was the initial framework. Through evolving over time, some beachfront leases went down the beachfront there, and they were terminating initially. Market didn't really like terminating, it was before that sold. And so long discussions were had, and they entered into perpetual agreements. And so that kind of got us the uptake. And why we a little bit upset about the nature of perpetual leases, most effectively a permanent alienation of the land. Had it not been for those perpetual leases, we would have lost the land through the rating scheme and various things, because that income has sustained us. The natural, the vegetation areas on our farm are a consequence of just not being able to access finance. It's pretty much for the whole local. A lot of the vegetation across Māori land is that they just never had access to finance because it was Māori land. And now, they're special areas. But that has been a large constraint, and our farming operation was quickly losing money. And so it's the rating scheme is, we're lucky we get farming concession, which is an old thing, ours to lose now. But as a beef operation, that farm operation would be paying, without the farming concession, around 60% of its gross income in rates. I don't know anywhere else in the country here that kind of scenario. So through the rating scheme, it drops down to somewhere between 20 and 30% of our gross income, still more than the taxman would have to pay on our income. That's just because we were there when all these people decided they wanted to come into the license, like the millionaires, the billionaires. And so they pumped up the rates. That's why our rates are. But yeah, so through the beachfront leases, we managed to, I think there was a decision down in Whakatu in the late 1990s that said that Māori landowners should be entitled to market rent on their field. And so that opened the way. So then in 2008, we actually started getting, so up until then, our people had never seen any other benefits other than $5,000 grants to both of our marae annually, and paying all the losses of the farming operation. And so that was, yeah, good 30 years. And then when we had a rent review in 2008, you might recall that it's just the big point of the GFC, so rentals were quite high. Although we entered into a rent negotiation process, which took us 4 years to get through, and we settled somewhere around the middle. That nevertheless gave us some additional capacity to then get a paid employee, because up until then, like again, a lot of Māori entities in the north, they don't have capacity to fund a manager. So we've got a manager, and from that, we've been able to start really focusing on getting efficiencies and creating wealth to deliver back to our people. So since we've bought 3 land plots, we've got 2 more plots over in Te Whāngai. They 274 hectares. In September last year, we've had a mortgage to buy another property in Waimata, so 100 hectares. So we think now we've got the right economic scale for one wicket as a farming operation. So he's maxed the capacity now, but he runs 4 blocks, which are 40 minutes apart, and that gives us the right economic scale to do what we do. We do Wagyu crossbred Angus, so we're a supplier for First Light. Kaputahi is our genetics program, so we're trying to increase the IMF in our Angus herd naturally, so that we cross it with the Wagyu. those attributes come through and we get much higher marketing scores. And what that means is less intensive on the land, you know, it's all about animal welfare. And yeah, so if we can hit 4s this year, then we're looking at $9 a kilo on the meat, which is quite a difference from the commodity market. So that's taken us 10 years. That's what we've really been focusing on farming operation, but the genetics on that farm and the other farms are finishing we bring to finish. And then the beachfront leases, yeah, they're all at different stages. So often we've got rent reviews on now, so that's that's an ongoing thing, trying to get the leases pricing settled quite easily. But if what we've learned is if there's not enough pension in the rental, then someone's getting, you know, more. And historically, we never had any issues. And we've seen this with other land plots who have leasing land where there's no dispute from the leasee, usually because it's well below market. And they just accept, and the owners just accept it. And the owners are scared of arbitration. We were scared of arbitration at one point, but we're not anymore. We realise it's just a process. So, but yeah, all the benefits that we receive annually are divided in 3 ways. So we go acknowledging the past that will be about to implement. That goes into reinvestment for all those to come. We're not getting any smaller, so we have to grow our assets. That's new investment that for our Maori whakatipu. And then another third is paid to our people here now. So that's we pay marae, grants, both sporting grants as well as tertiary grants. And then the residue is paid as a dividend to the shareholders. And we have 480 shareholders, but I would say the average shareholder has about 50 to 100 descendants. Some of them are trust, some of them are whānau trust. And so yeah, there's thousands of people that benefit from this. And yeah, we are going to look at providing for our people to buy it. Some of the farm that we bought in Waimate, it's historical land that was once lost to our hapu. And so at some point we will look to explore to create another pine here for our people as well, just to bring them back to Whenua. So, but yeah, so long answer, but just to provide a bit more overview to you about our operation.
Another one, sorry, you were talking about tension between the whakakainga and the residential, and that they want the same or are limited to what you want to achieve. And I just wondered if you could just say a little bit more about what were the shortcomings of that, and whether or not there was another alternative rather than an exemption.
Right.
Is there another model?
So residential activity means the use of land and buildings for people's living accommodation. That's how it's currently proposed. Whakakainga means any activity to support traditional Māori culture within the tangata whenua reside in the whānau district on Māori land, tree land. Whakakainga main purpose is not limited to residential, social, commercial, economic occupation. So I guess all I'm saying is that the residential activity definition there coincides. I don't see the difference. And so we've got 2 sets of rules, and it's not clear what is it managing. Are we just saying if you're just doing one house, that's not whakakainga? Or is it if we're only doing up to 10 houses, that's not whakakainga? Just clarity on that.
Sure, thank you for the presentation, and thank you very much for being able to verbally communicate journey that he was gone through. A question that I have, you put a slide up that showed the concept of wanting to do that development. Can you advise where you're at with that, and also your processes that you had to navigate through that? So it's just trying to understand the complexity or not complexity and all the various components that you go through to be lodged in the process.
Sure. So this is, yeah, as Martin said at the start, this is actually the second round of trying to bring this housing aspiration to life. So second time round. What's being prepared is that we've got experts all together in the same room. There's been an engineering assessment done, which is, from their perspective, all the three key matters, geotic matters, can be resolved. Mike Farrow from Little Riders is leading the placement and the design type. And yeah, where we're at is we've just lodged for a concept development meeting with the consenting team to ensure that this type of activity is going to be feasible. That's where we're currently at. So we're in a position where we can try and tie it down through a consent before this all comes in, as well as trying to, I guess, ensure that there's some certainty in the future.
There are, just to add to that, the question I got, the impression is the whole process. So that started with our farmer, and that was a lengthy process. The thing to talk to them about a subdivision, the thing to talk to them about the pros, the cons, and the benefits, and getting that resolution. And then from there, having to engage the bank, make sure that we're going to have this support, that we have this support. And then as we proceeded, we began the process. There were changes in banking policies. All the Australian, and particularly with our bank, it was to do with no new subdivisions and no new agricultural lands, the two primary businesses. So we got the bank in and we pulled them all in and talked them around, spent the day with them, explaining, because we've been with them for years, you know, and never borrowed from them. And so now we wanted to borrow from them, and doors shutting. So they said they would do it on a case-by-case basis. And so then we got hit by COVID, and COVID caused all that disruption. And so with all the uncertainty, there was no, we really didn't want to restart it until we did. At the back of this process here, though, there's still a lot of difficult routes to navigate. And that goes with creating the individual title, which is, again, in order to do so, you have to alienate those parcels of land through the One Land Court. And again, we're sort of going back to the whānau for resolutions, and then once they alienate the individual titles, and then they'll have to go back and be converted as public. So for Māori landowners to do this kind of thing, it is quite a process. But the only other group we know of that's done something similar is Kukaha Trust down in Pākehā South, and then further. You go through the parcel, and you've got Kāwhia, Rotamā, Raglan. So there's other blocks across the country. That's just, yeah, I guess, giving you a view of the whole process that we have to navigate. It's not just, we also got one land to navigate for.
Just one more question I wanted to ask the planner at the table. So in the council's process for planning, there's the component that talks about how plan works. And as part of that spatial layer component, there's reference to development areas. So by reading of this, development areas have the ability to consider integrated for mining development. My question is, sorry, and so that's the ability to, as you say, we have to keep going back to the farmer, but if you have a wider, bigger master plan with larger plan, outline development plan of some sorts of what you may want to do, then it becomes part of it would need to go through, no doubt, a plan change process, say, but you've got a map for the next potential so many years of what you're wanting to do. Just to ask the planner, is that something that would be of interest?
I think conceptually, yeah, it would be for those larger land holdings, perhaps something they would be interested in. And as an example, it's something that the likes of farm holdings are looking to do. If you're talking about development areas such as that. So I think it's conceptually something that mighty landowners in the larger side of things may look to uptake, but my experience is they won't. Experience is that it'll be a very hard proposition to get across the line, and so the reliance is on the plan provisions. For bigger blocks, it's 10 houses will come see us.
Just to refine your, it would be difficult or hard to navigate. Would that be from the mining landowner's perspective and from the difficult from a council perspective, or just want a bit of clarity? Might make it easier. Well, it's more efficient.
Yeah, I guess my comments come from I'm yet to see it happen.
Okay.
So, hey, if someone can crack it, then yeah, it's possible, of course. And you can see that. So,
We have done 30 with our people. So we've got big goals for 3 years. But it's always important to make them along the process.
Yes.
So that touch base.
Yes, yeah, and as you say, it's future planning from that perspective. I suppose my question why I've asked for that is the navigating that complexity, and it's case by case is on too, as opposed to full picture and where they may change the wrong way, that's what we can navigate through a resource consent process, whereas the big picture is pretty much set. But and we've already got the plan and the focus, and it's also involved in doing over the years. Yeah, that's where I was going. Thank you for that.
We have my grandmother's input in the time to experience there. Very much a living impact. We have always titled what that land was lost.
Thank you.
Oh, kia ora, tapu pātai, wari. Something I, in a Waitangi tribunal hearing. The delays that you had, to meet all these requirements. Have you ever calculated the negative loss potential? The ability to have housed people years earlier, the loss of years in community building, or it's just something you've got to do.
Yeah, no, we haven't done that. There we are looking to. This was previous coastal residential, so we kind of saw this as the first step and an easy opportunity. But there's above our playing entity, there's also a parcel of land that we could use for our bonus, our kindness grant, and so this would be the learning to then go and do more housing development over there.
in your 30-year plan, what was the time frame that you wanted to have on this housing?
Well, the 30-year plan's very high end, so we said quite much of the surveyed our people, just drew pictures. You know, what does the future look like in 30 years? And so that's what we look at around all the different strands of our strategy. And when we have to go write 5-year plans, strategic plans, which we're planning now, we look at that. Unfortunately, the subdivision now goes across 2 strategic plans. So, you know, and 2 to 5-year strategic plans. So it has been quite a delay, and there has been a cost because all the planning work that we started previously, it's kind of be redone, you know, with the engagement with the planners and stuff like that. So yeah, and so there is a cost, it just has to be calculated.
If I may, yeah, look, I'm just wondering, I have a few questions actually, in particular Mr. Says. But I'm wondering, and I haven't spoken to Teresa, but maybe there's been some reference to the total day and that exception. So I'm wondering whether it might be helpful.
Yeah, that's one question.
Yeah.
Coming from. So maybe I will allow you sort of question through questions necessary.
Yeah, I'm wondering first though, I think that that's what everybody's maybe that's the panel and this year, the rationale behind type and how that you can
Yes.
that'd be
Yes, that'll be helpful because obviously it's obviously seeing the same trend with Curry Bay as resource consent, and there is there.
I think, Mr. Chair, it's something different from what we've heard from Cavalli. It's a different patch of land, so I think.
Yeah, okay. So we still like the system.
So just through the draft, notified draft, a proposed district plan between the application of draft and the proposed Methodix provided the what kind of mention the to council and provided the public kind of management plan, which is essentially met the public kind development and the request. So that's referred in the together section 2 report post in 2022. And our feeling then was, of course, they came with the Papakainga management plan, and the management plan had already was in progress in development on the specific sites for the lots in DPs that provided in the proposed district plan for more time years. That development will began. So that's being brief for the reasoning behind to provide for that development plan for more time years.
Yeah, okay, that's separate from Cavalli, which is commercial
Correct.
operation.
Yeah.
So,
It is at the Tiny Bay. It is.
but within the different law closer
No,
to
it's actually closer to it's between the Cavalli properties and the beach, so it's from sensitive one direction, so it's more east.
I know, so where there are some structures.
Yes.
Yeah. I
So
know.
you've been to this site?
Yes. And we visited it as a result of another hearing. So, yeah, no, I understand that you're talking about sort of quite old, it's really quite close to those ones.
Yes. Yeah.
Okay, so your point is that they've provided a detailed public housing plan with numbers spatial. So
Yes.
how would that differ from the plan that's presented to us? Because obviously, like, we can talk about where,
Yes.
we know where that public line wants to go. We've got a pretty good idea of how many, how big, spatial. How does that stack up? What else would it need?
Well, I guess, and it's kind of because I need a certain, infrastructure. Information. I think another factor that, with Matali Eats, of course, was the, yet to be stood up wastewater and infrastructure that Matali. They also potentially has capacity for Matali by Kainga, although currently I'm not sure that they are on site. But there is some capacity provided for the particular system that's proposed, but not stood up. I haven't looked in detail at the provisions information here to see what that capacity is.
So at least the customer leasehold properties, they're all self-service, each site has its own, that's basically a small scale setting.
We're talking about technology.
Yeah,
Yes.
sorry, I'm assuming that's unserviced, but unserviced is individual setting.
Yeah. Students. I was thinking more of this, the
So
plan that's proposed several times previously.
So this one's a policy, it could be a communal system or.
I think, Mr. Chair, like the turnaround time in terms of the detailed information doesn't allow us to. However, we have that information and the evidence given, and we will look at it as something that we just a little bit of time to read through. So I don't think we have a position on it as staff as a recommendation to the pen yet, but it's something that's been provided through. I think another part of my question, to just a sense of it, is that the scope of the request appears to be, while that is a part of the request, I kind of, there's a couple of different legs of it. It appears to be that, and will respond to probably the census position on public versus housing. I think there are some quite obvious distinctions there in terms of who is what and potentially. So I think, again, look through those with you. There was again, some clarification, and I just missed Mr. Sense's answer on my recollection was that we talked about that the land should be, the development capability should be based on capability assessment, but that Mr. Sense was also opposed to having capability assessments as part of the provision, and I was just a little bit, wasn't sure what I did.
I can flesh that out. And I'll just break up the. I think it's MPZ S6. Which talks about servicing and MPZ 6. Do that. New buildings or structures, relocating buildings, extensions or alterations to existing buildings needs to be have a site servicing report to be permitted. That seems bizarre to me. So that's where the distinction is that policies saying, let's work on the carrying capacity or servicing capacity. I guess my miscellaneous quote was that this rule seemed to come there feel there might be some unintended consequences for certain benign activities. Yeah, if I was to alter one of the buildings 5 square metres, I want to provide a wastewater report, stormwater report, and a reticulation report to be permitted. So that's just the cost of doing business. I think it's an unintended consequence, or perhaps an error in how the rules need to work. But when I type in MPZ of S6, it only relates to that rule. So I don't need one for a public home. So it's just some struggling to follow the plan logic on that basis. But I think we've got policy saying, hey, if you're, in my view, if you're a larger site, we've got natural and larger carrying capacity. So why don't we land on 10, or why don't we land on 140 as the underlying. But just if I can comment, sir, with your pleasure, public climate development plans. Yeah, if that was the test, I think every Māori landowner would have done that as per a submission to potentially get an exemption from certain rules. And if I reflect on other local authorities, this is the provision of a public climate development plan on a district is a tool that's available, and that's how they've done it. They still have the underlying zone and they have public climate overlay, just for your benefit.
Yeah, so this is the area I wanted to ask a question on, so multiple and that is, if you are exempt, my question was then what is the mechanism to determine capacity? And then I think the answer has, well, there is a mechanism around, which is the public climate management plan process. I'm not sure under what legislation that comes in. Is it a thing under any of the, just an agreed sort of local government thing, or it's got stuff no acts behind it?
Can I perhaps just add some flavour to that?
So my general question to you would be, if you are exempt, then what would be the mechanism to determine capacity, either through servicing or whatever carrying capacity needs? How you might answer why you want to control, it should be up to DG, you decide how much. So assuming that there should be some level of what is that mechanism?
So the regional council, sir, has earthworks provisions, units. They manage discharge. In this context, so you've real wastewater managed for large scale. You all have earthworks managed. Water and stormwater, sure. Perhaps the Building Act covers that. Well, in fact, the Building Act does cover that already. Moving down to site specific, this is only an exemption to the overlay rules. So we've still got to think about, you've still got traffic controls, you've still got earthworks chapter, you've still got signs, lighting, you've got traffic, transportation, parking. The list goes on, and even if we were exempt, in terms of the number of houses, I'd say we still need to consider under the plan.
So you say that the regional plan set the limited standards for wastewater.
2 tubes per site,
Yeah,
2 or 3 tubes per site.
and you would adopt a residential regional for the public area.
I don't think you need to adopt it. You've got to meet it. Yeah, you've got to meet it.
Yeah. That's what you're saying. The same apply to water supply and still discharges. The same that the regional plan determine those things.
And the Building Act.
And there's engineering standards that come in there somewhere as well, right?
Sure.
No. Again, as I say, what of the mechanisms that would be otherwise constraining setting limits to what people do and then we're not limits.
Yeah, sure. That is the question, right? You've got a team or is everyone comfortable with that approach? And it is, that's way to go, but it's, if you stack up those constraints, I believe this is what those constraints are telling us is that, hey, it's already hard. It's already hard before we meet this door, which is the council door. And then we've got further infringements. And so, the status quo is we come and get a consent from council. They tell us like yes. And they've got to get a regional council consent for the same matters as they've got on the site. And then we come down to building consent. And they say, oh yeah, you've done what we've said you should do at the start. So, it's these touch points which, all the other constraints aside, I think the average punter on general land is starting to get fed up with, but in terms of Māori land, it's like, oh, there's another. Yeah, so hence why the position is good. Exemptions, yeah, would help.
Okay, great, that's helped clarify things. Just to understand, to the beach, it's a private road through there.
So hub rates, we just sealed it.
Could anybody drive out onto the beach?
No, because it's not restricted access. It's a farm.
Yeah.
And so that's why there's a gate, and so we don't actually own the electronic gate. That's owned by the tenants. But they didn't want to get out of their cars to open the padlock gate, and so they asked us some time ago if they could put their own gate in, which we allowed them to. If it breaks down, then they do have to use our gate inside, which has got a padlock. And it's just to keep the stock and to working for it. So it's just consequential that the subdivisions on the other side where they have an easement across the farm.
Okay, thank you. And can I just come back to you guys? It's just council office, just to clarify that. So, were you saying that one of the reasons why you allow governments to have an exception was that they had this process and train knowledge stuff, and but the benefit plan process itself is sort of a council initiated process.
No, it's self-initiated, much the way it's
So they said that it's still exempt from their
benefit was we doing this every day and through the drive.
So this we've obviously worked on this for some time. And that's why I asked the question, well, how far along the line this the plan that they put up on the screen, how far away, how long that process would that be? You might want to think about that.
Yeah, well, yes. I mean, at first blush, maybe, the devil's always in detail.
Correct. And but then again, here I was asking, says how much do you need to control? And given that we have till pretty much next year, or we deliver any recommendation, that gives them an opportunity. So
Mr. Chair, I think there is, and we contributed to it, there will be announcements on Friday from Senate government on rising plans. I feel the goalposts will move on us with short that in terms of what we can do ahead process. Because across the bottom at the moment. And we've been very, because we've been in the process, quite behind as much as the direction that we're going to see. So look, I think realistically, no matter how we cut it, we're going to be, doing something different, coming sort of a few months from now. So yeah, but absolutely acknowledge that. But we've got something before us. My sense, I guess, that maybe another couple of final questions to follow up is, in terms of scope, is what have been provided the starting point? Or are we looking at, is it an end or the exemptions across dwellings outside of that proposal? Maybe that would be a helpful question for us to understand as well.
Yeah, so it seems to me that your main thing is Papakaia. But also you want to see these properties reclassified as urban rather than rural.
That's it. My question is the balance side of the rural side.
Oh,
beyond the, beyond the
What's identifying in that?
Yeah, so that's a big question. Do you understand that question? Sense?
Yeah, it does, yeah. So the question is, it's outside of the new twinning that we want the exemption, I think. The answer is yes, but I think that the evidence I've provided is that to match Matoni Epson that's come with a development plan and there was similar interactions, so I got them right here, so.
So I mean, I suppose that's why we can say, oh, we want a Papakaia here. Then obviously the rest of the land isn't going to be so Papakaia. As you said, it's growing Māori population. But having said that, we still make it.
that balance.
Yeah. Okay. Right. I think probably needs to move things on. Sorry, do you want to say something?
No. Getting close.
Sorry, yeah, just a quick question. Actually, it's more probably a question for council. Can I ask council a question? Yes. So my question to council is, how does council plan to support tangata whenua through these Māori zone, through settlement overlay, land overlays, to navigate these, related to resource consent processes, or what support can tangata whenua receive in regards to navigating zone entry patterns?
So I'll give you the what we currently do is Teresa does provide support for landowners, particularly through some of the parts of the Māori land court processes. Council has passed a resolution as of last week before, specifically realigning direction of council to support the development of Māori land. So advocates for landowners in that space. So there is active work underway to be able to support that.
Okay. Right. And so would that also potentially include things such as guidelines on how to navigate planning processes? I mean,
it's probably too early to answer that question. Guidelines can be helpful, they can also be unhelpful, and everyone with different aspirations. I think guidelines are often really about control and direction as opposed to being inspiration. So my understanding of the wish of a Te Kuaka committee, where the question should come from, is that there's somebody that works alongside each whānau who will be ready to support what your aspirations are. So it's probably an alongside sort of proposition as opposed to here's a list of ways that you need to do that. So
thank you. Thank you.
Ia te kia kōru mai tuani pia, whānau ki nei te rongo ki o kōrero ngā ngamai, ka pai roa, moto whenua, kāra ki o tūpuna, kapua I kahi o ngā tauri o Matukira whānau. I roto I te kaunihira I tahi wā, he momo anesthetic pia te āhua o i na i rongo ana ki ngā mama o te Māori. E nā ka uru ngā reiti whenua Māori. So, nā mihi kia koutou o tō taki and korua rawa tēnei tukana and ieri haere ki tapu ai tahi te nui mo te wā ia Labour Day o te whakatautai wakaanga hātini te reira I ki te hau te tākua o reira and aroha I orite o kōrero ki ngā kōrero ai wāhi o whangaroa neana I te noho o ngā Māori tata ki te takutai, ka nui ngā reiti. Nā te nui o ngā reiti I te mea kei te taho te moana. Kāre rā te tai te mau ki whenua, te ngā wāhuru. And aroha kia koutou mō te tako ware, ke tōmuri tango e nei tukana aroha. E mōhi au I ke mea tatare ana kuma te whānau te tūwhare rungi ko mātou whakakainga. And I rongo mātou e tino tata mātou ki te tīmata, inga te haere te pēki pūte a me mai rātei. Ko aukati tērā pēki pūte e te mea horekau e tino activity o whakaro, wow, mena horekau e pēki pūte, horekau E tatai te pūte te inga, te pūte hei āpina te tūki whare. Aha pōko tatari e ono ngā tauta. Nā mihi kia kouta, eni awa. And tēnei taku whakaro I o te kauningera e tahi wā. Kāore te tangata, e tino mōio, te mama te kauri, tapai roa. I roto e nei tanasi. I te mea, te nui mo te wā e koro ana mō ngā mechanisms. I ngā ka mea te mito e wika kia maia, e ko te hihia, kia puta mai I kōranga e te tika.
Certainly nothing to add to that. Thank you. And thank you very much for your submission and evidence. The presentation to us today and the answers to our questions. Been really interesting. It's excellent. Give us plenty. Thank you again. What we're going to do is we're just going to take a wee sort of convenience break, and we'll sort of report parts of the
Just say the room.